Lawyers tend to be something you don't like very much, but then when you need us, you love us. So welcome to my most esteemed panel. You want to go ahead and introduce yourselves?
Sure. So my name is Dorna Moyni. I am an associate at Sidley Austin, and I work here in the Bay Area. I do employment litigation on the management side, which means I work for all of you companies and not for the employees who are suing you. Most of my work is class actions, and then also a lot of discrimination and harassment and retaliation lawsuits. I also help employers on counseling, employment counseling, regarding intellectual property disputes such as trade secrets, and just how to get your policies in place at the beginning of, when you start your company.
Thank you. Eric?
And I'm Eric Ferrari. I'm a lawyer in Washington, D.C., who runs a small practice that focuses on compliance and licensing and enforcement of U.S. economic sanctions. In that regard, we do a lot of work with startups and other tech companies who are seeking to transact with Iran in particular, helping them comply with the law, and have also defended a number of tech companies who have violated the trade regulations that are in place. So I think we have some information that you may find useful.
Tech companies don't violate, they disrupt. Okay.
That's right. Sorry, disrupt.
My name is Ryan Shaning Pocrasso. I'm the founder of Elevate Law and Strategy. It's a small law firm based in Oakland. We work with both for-profit and nonprofit startups, and particular focus on working with those who have some sort of social mission behind their work. So we do entity formation, employment law compliance, regulatory compliance, financings, intellectual property, and a lot of custom contracts.
Welcome to you three. So I'm going to get right into it. So as you guys all know, the U.S.-Iran deal just passed. Please congratulate yourselves. All right. Eric, talk to me about this. I can do business with Iran now, right? I have a startup. I can start hiring people.
Can you do business with Iran? Well, let's actually poll the audience first. Who is excited about the opportunities of doing business with Iran? And who believes that you're going to have a lot of new opportunities in the spring to do business with Iran? So I like San Francisco because everybody's very optimistic and hopeful. Unfortunately, where I come from, my part of the country, people are not as forward-leaning. To be frank with you, there are going to be no revisions to the primary sanctions embargo that is going to impact this particular industry. You got to think of the sanctions relief in the Iran nuclear deal as a reset to what was in place in 2010. Okay, there are some mild revisions to the primary sanctions that are in place targeting Iran, but nothing that would completely open up trade between the United States and Iran. So what I wanted to do here was, one, give you a little bit of background on what I'm talking about, what the trade embargo is, what it prohibits. Two, I wanted to cover two questions that we get a lot. And the two questions we get a lot from this particular community is, can I sponsor, participate, or attend conferences in which my counterparts in Iran are also attending or participating in, things like iBridges, for example. And then two, to what extent can I work with Iranians? So let me just give you the very kind of 30,000-foot overview of what the Iranian trade embargo is, and I'm going to be referring to it as the Iranian transactions and sanctions regulations, or the ITSR, because that's what we call it in the OFAC bar. Basically, what this embargo does is it prevents U.S. persons are defined as citizens, green card holders, wherever located. So if you move to Japan and you want to do business, you still have to comply with these regulations. Those physically present in the United States, so people who are here on visas, and then any U.S. companies or any U.S. owned or controlled foreign entities. And what it prohibits is it prohibits the importation or transaction in any Iranian origin good or service. Okay, so for example, many years ago I had a girlfriend who went and got a nose job in Iran. I immediately told her, hey, that's actually a violation of 560.206. The relationship ended.
And she dumped you, yeah.
The relationship ended shortly thereafter. I don't think it was because of me. I just think that's the way life goes. It also prohibits the export of U.S. origin goods, services, and technology to Iran, and it prohibits facilitation of the transactions of foreign parties dealing with Iran. So if you can't do something directly with Iran, you can't help a foreign person do it as well. It also prohibits new investment in Iran. And new investment is such a broad category that it's defined as contribution of funds. So let me give you an example of what that means. You have a bank account in Iran, it's collecting interest, you are engaged in prohibited new investment in Iran. Okay, there's actually been civil enforcement cases, there's been criminal cases that I've handled and taken to trial on this particular issue. So we're talking about a broad and sweeping comprehensive trade embargo. Okay, there's the doom and gloom. Here's the little sliver of hope for you. There is a general license, which is just a general authorization for the export of U.S. origin goods, technologies, and services, particularly related to hardware and software, that is incident to personal communications. So things like social media platforms are allowed, laptops are now allowed, cell phones, things of this nature. So it's not all bad news for this community. But the takeaway here is that there's still broad prohibitions in place, and those broad prohibitions are not going to change as a result of the Iran nuclear deal. So anything you're reading about, it's open for business over there, there's all these great opportunities, take it with a grain of salt. I know what's being said in the media. I know that there's people trying to drum up business. You've got to be extremely careful here. And here's why. Because the administration is going to have to answer to Congress, and Congress is going to be watching every activity that U.S. companies are doing, that U.S. entrepreneurs are doing, like a hawk, because they didn't want this deal to go through in the first place. So at some point in the near future, Congress is going to be calling for scalps, and you don't want to be the person who becomes subject to an investigation or an enforcement action by virtue of getting in to the market too soon. Okay, so that was bad news. Let me answer some direct questions, and these are the ones that, again, I get from this community all the time. Sponsorships. Can I participate? Let's start actually with conferences and sponsoring conferences. Can you, as a U.S. person, sponsor a conference in the United States in which an Iranian person attends or participates? Keep in mind, Iranian is defined as anyone who is ordinarily residing in Iran. The answer is yes, you can. There is a general authorization, again, for your sponsorship of that conference. So iBridges that happen here in San Francisco, completely in line with the law. Can you sponsor a conference in a third country in which Iranian persons are attending and participating? Yes, to an extent. So there's another general authorization, and what it says is that U.S. persons can sponsor conferences in third countries, Germany perhaps, where Iranians are attending and participating so long as, one, it's open to the public, and two, it does not focus in part or in whole on Iran. Okay? 3, can you sponsor a conference in Iran? The answer is unequivocally no. There is guidance on OFAC's website from 2000, so it's been out for 15 years that says you cannot do that. What about participating, speaking on a panel? In the US, the answer again is yes. In a third country, there's a major concern because your participation, you're speaking on a panel with parties from Iran who are also speaking on a panel or otherwise speaking at different panels at an event, could be considered facilitation. But for your participation, you would not be able to participate.
So Eric, what about hiring a developer? Because I know a lot of us here are like tech startup founders and they work in startups. Can I hire a developer?
Absolutely not. Okay, so actually this is a case that I handled where an enforcement action came out last summer. There was a Boston company that had hired web developers in Iran, and they were fined $82,000 for using the Iranian-based web developers to build their enterprise software. So there's that aspect of it. What about going the other way to Iran? Can you advise startups in Iran? Can you mentor them? This is a question that was always kind of a gray area. I think there's 2 points to keep in mind here. One, there's still a prohibition on the export of services, okay? And your mentoring advising could be seen as a prohibition on prohibited services. And 2, there is no requirement that compensation be paid for a prohibited export of services to occur. So it doesn't matter if you're doing it for free or out of the goodness of your heart. And I had a conversation with a State Department official about this. And I said, well, what about mentoring? Just kind of giving advice to these kids over there. And they said, you know what? Sounds like business consulting to us. So my advice is to not do anything without at least getting guidance or authorization from Treasury.
Thanks so much, Eric. So, I mean, this is a nice segue to our next topic, which is the whole independent contractor versus employee issue. By raise of hands, how many of you guys take Uber? A lot of you guys. How many of you guys take Lyft? So you guys know that a lot of them, both of them have actually been sued in class actions, right? All right, well, we'd like to talk a little bit about that. So what is this whole independent contractor versus employee controversy, and why is it a big deal to startups?
So this is a really important issue, especially for startups right now, because a lot of startups right now are using a virtual workforce, meaning that their employees or contractors or people who are doing work for them are located all over the place, potentially all over the world. And the lawsuits that have happened for Lyft and Uber most recently have ended in, or have resulted in, a few kind of bad rulings for employers. So Uber received as you guys might know, a ruling by the labor commissioner, the California labor commissioner, saying that one of their independent contractor drivers was an employee and was misclassified as an independent contractor. Of course, one thing you should know is that the labor commissioner in California is very employee friendly. So this doesn't necessarily say what's going to happen to Uber on a grand scale. That's what's happening in the class action. In the class action, the court has said that the employees can go forward with a class action, and that there's a potential that these people who are now these drivers who are now classified as independent contractors could be classified as drivers. No authoritative ruling has been made there, but it really makes an important issue for employers to look at some of the factors that are important for determining whether someone's an employee or an independent contractor. There's a lot of factors, and courts look at all of them together and balance them back and forth. But some of the ones that are most important are the level of control an employer has over these individuals who are working for them, how integral these people are to the business. So, Uber has these drivers, that's basically their entire business. And then who supplies some of the tools that they work with. So the Uber drivers, they bring their own cars, they're using their own cars to drive. So those are some of the factors that courts will be looking at.
So Ryan, you're a general counsel of a lot of these startups. How do you protect against this? How do you prevent your fledgling startup, from getting sued in a class action?
We make no guarantees to start. Basically, it's a really tough area to advise on because these factors are not something that you just look at and count the factors on either side and then make a decision. As Dorna mentioned, it's really a holistic picture of the overall scene of what's happening between workers and employers. And so basically what we do is we go through these factors with our startup clients, and usually the answer is, if you want to be safe and be sure that you're not going to be sued, then treat them as employees. Of course, that's very expensive, and it's sometimes completely cost prohibitive. And in fact, we've seen startups go out of business on this issue. So for example, HomeJoy was a service that was providing cleaners in-house for people in their houses. And when these rulings started to come out, they looked at it and they said, there's a bunch of different things going on for our business right now. One of the big things is this employee issue, and it's actually cost prohibitive for us. Other companies are starting to build this into their business model. So, for example, Instacart. I'm sure a lot of you are familiar with Instacart. They've actually started transitioning all their workers over to employees. And it actually, in that context, it gives them a really good opportunity because it allows them to train the workers in a way that provides better customer service for their customers. So if you have to train your workers significantly, that's another factor that's really looked at, and they say if you're training people, they're not running their own business, they're not independent contractors, they are in fact employees. So we do a kind of risk assessment with folks, and we say, if you're not going to be able to treat them as employees, then here are a few things that you can do to try to limit your risk. But I think it's important for startups to think about how to in the current regulatory landscape, how to shape their business in a way that does accommodate workers being employees. I'll also mention that for startups, it also has a practical implication that a lot of them are now significantly involved in lobbying. The regulations for employee versus independent contractor determination were established decades ago, before Uber and these other disruptive services came about. And so, it's actually been a big challenge for these courts that are looking at these issues. And they've said, juries are going to have to put a square peg into two different round holes, have to figure out which one to go with. So I wouldn't be surprised to see some legislative change. In fact, the LA Times has reported that Uber now spends more money on lobbying in California than Wells Fargo, Bank of America, or Walmart.
And to follow up a little bit on what Ryan was saying earlier about how cost prohibitive it is to have employees reclassified as employees instead of as independent contractors, it's typically about 30% more costs added onto your business to employ someone as an actual employee, considering all of the overhead costs, payroll taxes, all of the other regulations that go along with being an employee that you now have to be aware of, and you're potentially, you could be sued for by employees.
Thanks, guys. There's a bunch of other startup companies that are also in tech have been getting sued recently, including, well, actually, no, I take that back. Well, Microsoft's one of them, but Twitter's one of them, and Facebook's one of them, and it's gender discrimination. I know in the tech community we have a big gender issue, and how have startups been combating that?
So this, I think, became a really big issue. It's been really publicized in Hollywood, as you guys know. Jennifer Lawrence came out and said, "I'm not being paid as much as my male coworkers." And then the Ellen Pao trial happened this year, and even though Ellen Pao didn't win her case, it was a huge issue across the nation, and people started to really bring up this issue, especially in the Silicon Valley, targeting tech companies who are a lot of them are predominantly male, and since that action, there have been a ton of new class actions based on gender discrimination, and I think that especially for early stage companies, some of the most important things to do to at least protect yourself a little bit, if it's possible, is to have good policies in place. One of those would be what we always advise our early stage companies. If you don't have any policies in place yet, the first two policies you want to put into place are a sexual harassment policy that has a complaint procedure, where if someone feels like they're being sexually harassed, they can go to HR and they know that's the policy. They go to HR, they tell them this is what's happened, and an investigation is then put into place. That can actually be an affirmative defense if you're ever sued for sexual harassment. And then the second type of policy that you should put into place is an equal opportunity employment policy, just establishing that you employ everyone equally.
And there's this new California Fair Play Act that just came out recently. Ryan, can you speak to that?
Sure, yeah. So starting in January 1st, there's a new law in effect in California, the Fair Pay Act. And basically, it imposes additional obligations on employers. So for one, employers have to affirmatively show that the difference in pay between a female and a male is based on skills and experience as opposed to on gender. So in addition to those policies, I think that there's some record-keeping requirements, and it's kind of unclear how folks are going to comply with this law because it's brand new. But I think documenting why you're promoting people, and in addition, promoting women as well is a good start. And then in addition, it imposes an obligation to not retaliate against employees who ask about pay of other employees in the business. So these are big changes that are only effective in California, and we'll see how they play out.